Good day, Crime Talk aficionados. We have a great show for you. I'm back. First, new motions filed in the Bryan Kohberger matter, and, well, let's talk about what they reveal. Karen Reed, her trial is set to begin. Lori Vallow is acting as her own attorney. What could possibly go wrong in the trial of the death of her fourth husband? Let's just admit it. It's creepy keeping dead bodies in a storage unit. We have this day in legal history and our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications so that you know when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Now, I know I was a little absent last week. As I told you, I apologize in advance, but I was in trial. That's what real trial attorneys do. They go to trial. And guess what? We got the big not guilty. Now, I still got to go back. That's why I'm dressed casually today. I still have to go back. We're going to resume the trial tomorrow. Another trial, same client, different set of facts. But the big one was last week. All right. Yes, it was we're talking wiretaps, the whole kit and caboodle. They threw everything at my client and guess what? Not guilty. That's right. So when you're looking around for, people, do they know what they're talking about on YouTube? Ask yourself, when was the last time they ever went to trial? And ask yourself, when was the last time they ever actually did a homicide case? Anything along those lines. Anything. Just saying, ladies and gentlemen, when you're talking about who knows what the heck they're talking about, go to somebody that still actually does it. Now, someday I'm going to be one of those people. I hope to not have to go do, trials anymore. But hey, there's something about doing a trial. It's all the prep, everything. That's the worst. Sometimes dealing with the clients can be pretty bad. But when they say bring in the jury, it's like game on. It's like this is the biggest rush ever. God, I love it. God, I do love it. And I agree. Well, it is much more fun when you win, and then you don't have to worry about appeals and your client filing post-conviction relief on you. It's just a lot better when you win. All right, now that I explained where I was last week, guess what? I'm telling you, go to CrimeTalkSearch.com. Sign up for a background subscription service today, and when you do, you're going to be able to search as many people here in the United States as your heart desires. That's right, whether it's, somebody mentioned in a high-profile case you want to check out. Maybe it's somebody coming into your life, or maybe someone you think, I should get out of my life. Something just doesn't feel right. Maybe your spidey senses are starting to tingle. Well, go to CrimeTalkSearch.com. That background subscription service that you have will literally allow you to do the background search, get the results literally while you wait. It'll be emailed to you, and you can get updates as well, ladies and gentlemen. And here's the beautiful thing. You can cancel at any time. So whether you want to do 1,000 searches or just one, it's your prerogative. So go to CrimeTalkSearch.com. I'm telling you, we use it here every day. All right, let's go ahead and get to the docket for Monday, March 31st. Yes, that's right. The last day of the month of March. Can you believe it? This time last year, I had spent 4 weeks in trial in March. What is it about March? Going now 2 weeks in trial in March. Just a busy time. Anyway, kind of before we broke, we had a bunch of new stuff that came out in the Kohberger stuff, motions, right? There was still another stack of stuff that I still have to go through. And then on top of that, that's right, we have this new big stack here as well. But I'm going to go through it quickly, ladies and gentlemen, but there's a lot of big news in the Bryan Kohberger matter, all right? So first, the prosecutors have unveiled an essay. That's right, a college essay from alleged murder suspect Bryan Kohberger that allegedly shows he knows his way around a crime scene, according to some new and recent filings. In the paper written back in 2020 during a finals for a 300-level criminal justice course, Bryan Kohberger describes how crime scene investigators use fiber-free overalls, gloves, and booties to avoid contaminating the location with their own same DNA and fingerprints. Now, at the 1122 King Road address where the alleged murders took place, police have revealed little evidence aside from a K-bar knife sheath found under one of the victims that allegedly has Bryan Kohberger's DNA on the snap. Now, before the FBI identified him as the person of interest, though, investigators used genetic genealogy. His name was unknown to the detectives. Now, he went into other aspects in this paper regarding crime scene investigation, but repeatedly referenced measures police should take to protect the location, shared his thoughts about circumstantial evidence, identified domestic partners as potential suspects, and warned that crime scenes could be staged. Now, prosecutors are going to talk about this when they bring up the lack of forensic evidence left by the killer. According to people familiar with the case, they're going to say, look, how much he knew about a crime scene. He talks about wearing these fiber-free clothings. Now, Kohberger mentions the fiber-free overalls, shoe covers, gloves, hair nets, and more when talking about the protective gear an investigator should wear to avoid the contamination of the scene. Now, Bryan Kohberger purchased a mask months before the Idaho students were savagely murdered inside their off-campus home. And the surviving housemates, Dylan Mortensen, told police she saw a man wearing a same kind of mask around the time police believed that Madison Mogen, Ethan Chapin, Kaylee Gonsalves, and Zaina Knodel were all murdered back in November of 2022. Now, Kohberger desperately wanted his Dick's Sporting Goods purchase to be inadmissible in the upcoming trial, but the new court documents reveal prosecutors have insisted upon using the records because it could prove crucial to their case. Now, the relevance of this information is that Bryan Kohberger purchased the masks from Dick's Sporting Goods back in January of 2022. This mask is the same type of mask described by DM that she witnessed worn by the male in the house on November 13th of 2022. Now, a search of the Dick's Sporting Goods current offerings reveal there are 41 variations of this black mask or ski mask available, and it's not clear which one Bryan Kohberger exactly purchased. However, Kohberger's legal team has already tried and failed to have that critical DNA evidence and Amazon shopping history tossed from the case. The K-bar, the brown leather knife sheath, I guess I should be more accurate, featuring a United States Marine Corps SEAL, just like this one I just happened to get, back in 1988 when I went to boot camp. You really can't see it's a little faded here because it's all broken in, but there's a little Eagle Globe and Anchor. That's just the way they make them. That's the way they've been making them for, the last 80 years, ladies and gentlemen. Nothing changes on them. Anyway, they found that little sheath, right? The little knife sheath. And, look how long the knife actually is, ladies and gentlemen. I mean, that's going to hurt. That's going to hurt. Anyway, that sheath was found next to Mogensen's body in the bedroom on the third floor of the home. Now, there's been DNA on the sheath that was traced back to Bryan Kohberger using the IgG, the investigative genetic genealogy, according to the prosecutors. And obviously, it must be because that's why the defense wants it out. Now, while the murder weapon has never been found, Kohberger's Amazon shopping history reveals he bought a K-bar knife sheath and a sharpener from Amazon back in March of 2022. 8 months later, on November 13th of 2022, investigators believe this same type of knife was used to murder the 4 university students. Now, following the murders, Kohberger's searched to buy a replacement knife and sheath, according to the prosecutors. Elsewhere in new filings is a 12-page assignment Kohberger submitted in 2020 while studying for his criminology master's degree. Like I said, the paper details in excruciating detail how first responders are expected to handle crime scenes. In the paper, he describes how surveillance footage can be circumstantial evidence, but may lead investigators in the right direction and to the apprehension of a suspect. This may be the work of a serial killer, though this is highly unlikely. Kohberger concluded in his paper by arguing that if all steps laid out are followed correctly, the defense should not be able to discredit the investigation and render evidence inadmissible. Now, prosecutors are going to argue it displays his immense crime scene knowledge. Now, obviously, with the trial getting close, the defense has been filing a lot of motions to get key evidence tossed from the case and to get the death penalty taken off the table. In new court filings, Kohberger is now seeking to also limit his bank records, including PayPal and Venmo records, and the bank records of the victim being presented at trial. It's not clear what the contents of these records show or the relevance they may have to the prosecution's case. The filing also points to a purchase made by Kohberger at a sportswear company, Under Armour, on June 24th, 5 months before the murders. Now, Mortensen's recollection of the masked man was vague, other than he had bushy eyebrows. And the state will attempt to use a selfie Kohberger took just hours after the alleged murders of the students as part of their case against him. The picture shows Kohberger smirking and offering a thumbs up to the camera. The selfie appears to have been taken in a bathroom with a shower as the backdrop. Now, Kohberger wears earphones, has a colored long sleeve shirt that's buttoned down to the top in this little picture there. Let's get to the motions. I mean, obviously, we know a lot of the facts if you've been following the case. All right. You know, between 4:22 and 4:24 a.m. on the morning of November 13th, Mortensen and the other surviving housemate, Bethany Funk, exchanged 17 frantic text messages and, you know, basically saying they're freaking out and things of that nature. You can go back and watch the previous videos where we go through them line by line. Now, over the three messages, Funk's response: "Come to my room, run down here." Soon after seeing the intruder, Mortensen went downstairs to Funk's room, and the two went back to sleep. Now, Kohberger has offered so far a vague alibi for the night of the murders, claiming that he was out just driving around looking at the stars. Now, no witnesses have been endorsed to corroborate that testimony. So the only one that could really corroborate that would be, well, Bryan Kohberger. Do you think he's going to take the stand? I don't know. So let's talk about the motions. All right. We had a big stack last week. Let's go through these. The state's response to the defendant's motion eliminating number 5, inconclusive data. This was item 13.1 is a swab of the left fingernail clippings from Madison Mogen. Jade Miller, an analyst with the Idaho State Police Lab, analyzed the DNA profile from item 13.1. She found the DNA profile indicates a mixture of DNA with a major profile, which is consistent with having coming from Madison Mogen. It makes sense. It's her DNA, right? For her analysis, Ms. Miller assumed 3-person mixture and compared the DNA profile to the DNA of several other individuals related in the case. Her comparison provided likelihood ratios resulting to show the likelihood that each person compared contributed to the DNA profile. Ms. Miller then determined for each likelihood ratio results whether it supported inclusion or exclusion, or whether the likelihood ratio result was inconclusive. As Ms. Miller explained to the grand jury, just so you don't think I'm making it up, redacted, these ranges are consistent with the Idaho's State Police Lab analytical method in affecting the time of analysis. Applying those ranges in her likelihood ratio, Ms. Miller concludes that it is inconclusive whether the following persons are potential contributors: Jack Dukar, Cole Barenberg, Ethan Chapin, Zaina Kernodle, and Bethany Funk. She also determined it is inconclusive whether Bryan Kohberger is a potential contributor to item 13.1. The defense has disclosed Jennifer Bracamontes, a case manager for cybergenetics, and as an expert witness in this case. Ms. Bracamontes utilized a different program than ISP to analyze the DNA profile obtained from Q1 3.1. She determined that Bryan Kohberger could be excluded from the profile obtained from Q1 3.1. Defendant's supplemental response to request for discovery regarding that. Anyway, the defense wants to exclude Ms. Miller's inconclusive results to the defendant. That's not going to be excluded, all right? It shows that this is their analysis. This shows, you know, if you have a scale, right down here, you're not included. Then it goes to, well, it could be somebody, but we just don't have enough of a sample to do that, so we can do all our statistical analysis. And then, of course, up here, it's like, oh, yeah, it's absolutely him as a contributor, right? They're saying, no, it's right down here. The defense expert wants to say, well, we did our own analysis and we think it should be excluded. Well, that's a question of fact for the jury to decide, and that's what the judge is going to let them do. Next, use of the term psychopath or sociopath. The state notes that the defense recently put defendant's mental health at issue. It was their motion to strike the death penalty regarding autism spectrum disorder. We went through that in a previous video. Such an examination takes place and reveals an additional information about the defendant's mental health, or defense asserts additional information. If somebody has come up with that conclusion, they'll be allowed to use that as an expert witness. Use of the term murder. The Prosecution responds. The defendant's motion in limine regarding the use of the term murder. Defendant asks this court to prohibit the lawyers or witnesses from using the word murder or any form of the word murder. A recent Supreme Court decision there in Idaho, the defendant moved to prohibit the use of such term as the word victim. I filed this motion. This was the motion of the day back in the Kobe Bryant trial up in Vallow. It didn't go to trial because I believe there was a settlement in a civil matter that made her unwilling to return to the state of Colorado. Cha-ching. Anyway, there was lots of motion saying, hey, you can't use the word victim. Our client's been given the presumption of innocence. How can you refer to her as a victim if she hasn't been convicted yet? So anyway, that's what this one is about. Anyway, the district court denied the motion. The Idaho Supreme Court affirmed it. You're going to say it's murder. He's charged with murder. What are you supposed to say? He's charged with the taking of the life of somebody? No, come on. The charge is murder, for goodness sakes. Expert testimony, they go back and forth. It's undisclosed. Everybody's talking about. The defense filed a motion saying don't have any inflammatory evidence. That's going to be like crime scene photos, autopsy photos. But guess what? You're going to get them. You're just not going to get probably all of it so that it's so inflammatory. Anyway, the state responds saying there's a motion in limine regarding inflammatory evidence. Unfortunately, the defendant doesn't specify what potential evidence he is objecting to as exceptionally inflammatory, nor does the defendant define exceptionally inflammatory. And that will be denied. It'll be done on a case-by-case basis. Defendant's objection to the state's notice of intent to use 404B evidence, right? 404B evidence is evidence of other wrongs, acts, or misconduct to show that somebody acted to show identity, modus operandi, pattern, and basically some sort of, conscious skill. I don't have it right in front of me. It's 404B evidence, basically other rights. But it's got to be very specific. Otherwise, it's just propensity evidence to say, hey, look, this guy's a bad guy because look at all what he did before, right? That's what it is. Anyway, they are saying the state misconstrues the identity aspect of 404B because the August 21st, 2022 traffic stop bears no resemblance to the crime charged and should be excluded as evidence. When the state presented a video of a traffic stop, this is from the defense motion, on August 21st, 2022, and the corresponding citation of evidence to the grand jury, a limited instruction was given stating that the evidence is blank and sealed, redacted, just so you don't think I'm making it up. The state misconstrues the identity aspect of 404B. Evidence of prior misconduct is relevant only on the issue of identity when the evidence demonstrates sufficiently similar as well as distinct characteristics or patterns between the prior misconduct and the charged crime. When the other act evidence is introduced to prove identity, as proposed by the state in this case, the characteristics of the other crime or act must be sufficiently distinctive to warrant an inference that a person who committed the act also committed the offense at issue. Neither the video of the traffic stop nor the corresponding citation are similar to the charged offenses. The state has other ways of proving Mr. Kohberger's identity without a prior bad act. Now, normally that's the case, but they're trying to show that he had possession and control of the car, ladies and gentlemen, and he got pulled over for a traffic stop. The judge can give a limiting instruction, and frankly, this is not the worst kind of 404B evidence that could possibly come in. I think that will ultimately come in. The defense objection to the 911 call. Bryan Kohberger, motion in limine to admit hereby objects to the state's motion in limine to admit the 911 call and the accompanying transcript. The state relies on exceptions to the hearsay rule and the effect on the listener. It has to be excited utterance. One could argue it's a business record, but I think it's going to be come in as a present sense impression when the roommates testify. All right. Motion to strike death penalty. We kind of talked about that before. Disclosure violations, not a big deal. Motion to seal the state's unredacted response to motion in limine regarding inconclusive data. They did that. Not a big deal. All right, let's move on to the new stuff. All right, the new stuff, ladies and gentlemen. As you can see, part of the job of the defense is to keep the prosecution busy. If they're working on filing responses to all these motions, they're not prepping their case. They're not meeting with witnesses. They're not making sure everything's getting done. Okay. Now, this is going to be an interesting one here. All right. This is the state's reply to the defendant's objection in regards to the motion in limine regarding self-authentication of records in reliance to Idaho Rules of Evidence 8036, business record exception, and 902.4 and 11, and Idaho Rule 803.24. All right. And you may think, God, why are we even bothering with this? Well, this is all about the stuff, right? This is where the real lawyer stuff comes in, because you got to be able to get it all into evidence. Well, how do you get it into evidence? Well, first it's got to be relevant, right? Then you have to show that it's authentic, that the records are authentic. And how do you do that? Well, normally you bring somebody in to say, this is what it is. This is my video system. These are my business records. I have a duty to maintain the accuracy of these business records. And what the prosecution likes to do a lot of time is say, well, we just want them to be self-authenticating. Here's our business records. We maintain them in the course of the business. It should comply with the federal and state rules. And more than likely, they're going to come in. But in a homicide, a quadruple homicide, man, don't get lazy, Mr. Prosecutor. Just bring the witnesses in, for goodness sakes. Bring in a representative, all right? So let's go through this. Now you can see how thick it is. All right, we're not going to go through everything, but we'll hit kind of the highlights. All right, the state, through the counsel, respectfully replies to the defendant's objection to the state's motion in limine regarding the self-authentication of records. The state seeks to rely on self-authenticating evidence as opposed to calling foundational witnesses in order to accomplish the same. It is understood that admission would be contingent upon the state laying the proper foundation with a certificate of affidavit under 8036 or 8 and the requirements of 9 IRE Idaho Rules of Evidence 902, 4, or 11. It is also understood that admission would be dependent on the state showing the relevance of the evidence, replying specifically to defendant's responses. First, the 1320 Linda Lane surveillance footage. This footage is maintained by a property management company. The state would seek admission of the footage pursuant to 8036. The relevant footage is taken on November 13th, approximately 0.3 miles from the 11 King Road house, the crime scene. The state may rely on video footage from around 3:29 showing the suspect vehicle in the area at the crime scene. And they're obtaining a certificate of authenticity. We'll just bring in somebody from the property management company and saying, this is our video. We maintain it in the regular course of business. All right. And we would, it's a fair and accurate representation as it existed at that time. Now, the defense, I think, would argue, if I was them, saying, Your Honor, this thing, I would do a little voir dire on the witness. Sir, you don't save all of your video, do you? Well, no. I mean, it goes on a big disk and, you know, it's saving itself. And after about 30 days, it gets taped over, right? Yeah, it probably does. Yeah. So my position would be is that it is not a business record maintained regularly, that is in fact made in anticipation of litigation, and therefore it's not a business record exception. And you can't get around either the 904 exceptions either as well. But hey, don't listen to me. I'm just a little old trial lawyer. Then we have the 1330 Linda Lane surveillance footage. Once again, maintained by a property management company. Same thing. Albertsons. This footage is maintained by Albertsons Grocery Store in Clarkson, Washington. The state will seek admissions of this footage pursuant to 8036. The relevant footage is taken on November 13th. The state may rely upon video footage from approximately 1246 to 106 p.m. to show defendant's vehicle and actions hours after the homicide. Amazon financial records. The purchase history. The state is attaching a certificate of authenticity dated on this date under 8036 and 90211. The certificate was included with an Excel data file that details Bryan Kohberger's subscription information and order history from January 5th of 2022 to December 13th of 2022. At the trial, the state intends to offer a certificate attached to the records as there as well. AT&T phone records, certificate of authenticity. As it relates to the various phone records between June 23rd, 2022 and December 23rd of 2022. The Bagel Shop video. This footage is maintained by the business. Seek admission. It shows the footage on November 13th from 1:40 a.m. to 2 a.m. Provides a timeline for the events. Bank America bank records. Now that's a true business record, right? They're in the business of maintaining accurate records. They do it contemporaneously when it takes place. That is the classic business record exception, so that it's not a hearsay record or hearsay document. Banner bank records. So the state no longer intends to rely on this evidence. If the state does, it'll lay the proper foundation. Cafe Artista video surveillance on November 13th. It's a hard drive provided on 8:05. Admission of this footage is relevant. 8:03:06, approximately 1:04. I don't like the 8:0. I mean, just bring somebody in to say it's fair and accurate representation that recorded, the machinery was working properly. I don't like that, prosecutor, Mr. Prosecutor. I do as a defense attorney because I think it may be an appellate issue. So just bring the people in, for God's sakes. Why go cheap? You've got all this work. You got people in the town. Drive them over, fly them over from Moscow over to Idaho. Just do it. Corner Club financial transcripts. This document's maintained. Relevant portions, state's exhibit. Evidence provided a timeline of the events before the homicides, corroborated state witness testimony. Costco. Footage taken November 13th, 2022. State may rely upon the video from approximately 11:59 to show defendant's vehicle and actions after the homicides. DeSalle student record keeping. These documents are private university. State would seek admission of the documents. State is attached to relevant evidence that would introduce the defendant's knowledge of the crime scene. Dick's Sports. Obviously, the relevance is the information that Bryan Kohberger purchased this black balaclava. I guess that's where it's a mask. Anyway, and that the DM said that she witnessed one worn by the unknown male on November 13th. Discovery financial records, DoorDash records, early warning records. They're not going to use that. Elon financial records. State no longer relies upon that. ENS services. It's maintained by the business. Once again, shows 5:26 a.m. showing the suspect vehicle after the homicides in Washington. Farmers insurance video. State no longer intends to rely upon that one. Floyd's cannabis surveillance. Shows that at about 3:02 a.m. on the night of the murders, showing a white sedan on State Route 270 between Pullman, approximately 1 hour before the homicides. ForrestDaxCrypto.com, financial records for Bryan Kohberger. Related to the relevancy is the expert disclosure for FOA Michael Douglas. FOA Douglas is a factual witness regarding this account. The state is in the process of obtaining a certificate of authenticity. Grub truck video. Once again, approximately 1:43 a.m. to 1:53 p.m. The evidence provides a timeline for the events of KG and MM before the homicides and corroborates the state's witnesses' testimony. Harbor Freight business and surveillance records. They're no longer going to rely upon that. Idaho Central Credit Union, not going to rely upon that. Indian Mountain Lake surveillance and records. States no longer rely upon that. Jones Fabric financial records. State no longer intends to rely upon that. Latah County Sheriff's Deputy Darren Duke body cam video. Public record 8:03:06. Latah County Sheriff's Officer of the public citation in the process of certificate of authenticity. Marshall's financial records for Bryan Kohberger. National Weather Service records. Numerica bank records for KC. They're no longer rely upon that. PayPal Venmo records. This document is maintained in the regular course of business. Admission of financial records of the defendant pursuant to Idaho Rules 8:03:6. PNC bank records of Bryan Kohberger. Pentel data records. They're no longer rely upon that. Pennsylvania State Employees Credit Union. Maintained in the regular course of business. State would seek admission of the financial records of the defendant. Provide specific regarding the relevance of this information is in the expert disclosure for FOA Michael Douglas. State is processing Petco financial records, Rite Aid financial records, Ross financial records, Sunset Mart may rely upon video footage, Target financial records. State's no longer going to introduce that. TikTok user for XK. The records would show that XK on the TikTok application on November 13th at 3:16 a.m. The state is in the process of obtaining that certificate of authenticity. XK obviously is in chronodal. TJX financial records, T-Mobile records for KG and DM, Under Armour transaction records for Bryan Kohberger. Say they're no longer going to use that. U.S. Chef Store, defendant Verizon phone records, Walmart surveillance video, Washington Department of Motor Vehicle records, Washington Trust Bank, Wells Fargo Bank, and the university. Then we have all the attachments. These are the certificate of authenticity. Just so you know, we won't go through them all. Certificate of authenticity. I, Shane Cox, declare as follows. I am an employee of Amazon Inc. I make this declaration based upon personal first-hand knowledge, and if called as a sworn witness, I would testify as set forth below. Amazon produced documents responsive to the above referenced law enforcement requests. All documents produced by Amazon are authentic and what they purport to be, and accurately describe the transactions, communications, and events set forth therein. All documents produced by Amazon are business records as if they are records in the ordinary course of business, created at or near the time of the transaction or events reflected therein, or based on information from a person with knowledge of the transaction. Okay, we got AT&T. We got all this stuff. I mean, it just goes on and on and on. Certificate of authenticity. Now, what's the reason for that? Well, it speeds things up just a little bit, that's for sure, because you don't have to bring in the witness, say, "Do you work for Amazon?" "Yes, I do." "These records fair and accurate?" "Yes, they are." Okay. For example, some are a little more fancy. They get a little certification. They get the little seal on it. That's a federal government one. So yeah, that's all good. T-Mobile, Department of Licensing, goes on and on and on. But once again, ladies and gentlemen, it shows you, right? What have we talked about here, right? A good defense attorney looks at this and says, wow, I got some bad evidence. How am I going to win this case? I got to make certain things go away. And the defense is trying to do that, try to keep everything out. The state's reply to defendant's objection to the motion eliminated regarding the admissibility of demonstrative exhibits. As you may recall, the state wanted to put up a model, a 3D model based upon all the measurements and everything they took. They say, hey, it's necessary to clarify the history between the parties of the issue of the 3D model. It is true that the state's initial plan was to ask for a 2-scale 3D model of the 1122 Road King residence. As part of that, at least partially in response to Ms. Taylor's request back in October of 2023 for additional information, the state initiated inquiries for the underlying supporting data so they could review it on their own. Now, while the emails the defendant attached to the objection make reference to a scale 3D model, the defendant neglected to include the balance of the email thread, which includes emails between Ms. Taylor and Ms. Jennings on February 4th of 2025, and emails between the undersigned and Ms. Taylor from February 28th, and March 4th, where the state advised the defendant that the state had finally received supplemental information regarding the 3D model attached in the email, and that the state was electing to use a 3D model as a demonstrative exhibit for any witness who might talk about the residence, not an actual scale model. See the full email thread. Ms. Taylor's response to the state's inquiry regarding any concern the defendant has about a demonstrative exhibit is merely that she continues with the same objection as we discussed, and we express in email exchanges. The defendant's same objections are reflected in Ms. Taylor's February 4th, 2025 emails. The defendant now argues that the same objection is not to scale model without recognizing the difference in the standard for demonstrative exhibits. The state says, hey, submit that the not to scale illustrative model is no different than a diagram or a hand-drawn sketch or a floor plan. Now, we talked about this last time, right? A demonstrative exhibit is something that does not go back to the jury, but it is used to help the witness on the stand explain what they could do, right? So let's say you had a witness on the stand. Would there be something to assist you in, explaining where you were and where you walked down the hall? Well, yes, it would be. So if you had a nice model, you could say, I was here in my bedroom, and then I went here, and then I went up the stairs, and boom. Or you could say, here's a piece of paper up here on the wall. Here's a marker. Why don't you draw this, box? That'll be the house. Explain where your room is. Initial that and move down here and initial the path you take. Okay. That is not coming in as an exhibit. It'll be a demonstrative exhibit, and it doesn't go back to aid the jury. But the point is, this whole stuff about wasting time on a demonstrative exhibits not being to scale, nonsense. Just like the drawing on the piece of paper to explain it is not going to be to scale. So I think it is another one. And, if you're going to misquote somebody, defense, you include the entire email string, because otherwise it makes it look like you're being disingenuous as well. Then the district attorneys filed a notice of appearance for another attorney. They have now brought onto the team the Deputy Attorney General, Madison Allen, and they're going to appear as the state attorney in this matter, and Miss Allen will appear for limited purposes assisting the prosecution with jury selection scheduled to begin on July 30th. More expert disclosure stuff that they once talked about, supplemental exhibits regarding rebuttal expert disclosure, same stuff, get them everything, right? Give them everything, and we're still going to convict you. That should be the mantra of the prosecution. State's reply to defendant's objection to the state's motion in limine regarding admissibility of demonstrative exhibits. We already talked about that. Sorry. State's reply to defendant's objection motion eliminate text messages and testimonies. Now, remember last time they said, hey, you can't do this. Well, the government said, don't worry about it. We'll give you a breakdown. Here's the record. And they're going to say, here's our authority for the admission. Now, this would have made my trial a lot easier. I asked for it. I said, Judge, if these are, prior, or if these are statements in furtherance of this great conspiracy, maybe I should know now before the trial, could possibly resolve something. But that's what they did. They say, here's the time, here's the record, the DM, the authority for admission, not hearsay, not for the truth of the matter asserted. Now, I'm telling you, I hate that objection. Okay. Yes, you can say it's for the impact on listeners, for the context of the conversation, but it is hearsay. It's an out-of-court statement being offered for the truth of the matter asserted. And for the prosecution to say, well, it's not hearsay because it's not being offered for the truth of the matter asserted, just that the statement was made. Well, the witness can testify to that. What did you say? I said this, right? What was going through your mind? Why did you say that? Present sense impression. That's coming in, but not hearsay. If it's not being offered for the truth of the matter asserted, it has no relevance. Why would we want things that are not truthful on there? Then they go through excited utterance, but they at least give an explanation and they can determine these pre-trial. What the judge should say is, all right, I appreciate you all taking the time for this, and we'll take it up one by one as the evidence is offered into evidence. State's reply regarding the objection to the 911 call coming in. It says the defendant relies on DM's and BF's actions from the night before to support this argument that the statements on the 911 call cannot be excited utterance or present sense impressions. This is misplaced. The excitement leading up to and during the 911 call was not caused delay solely from seeing a male in the home the night before, but from discovering moments earlier that their roommates or friends was not waking up. This, in addition to also realizing that none of the other victims in the home were responding. The entire call should be admitted through the excited utterance exception to the rule against hearsay. However, if the court breaks down each statement made on the call, the entire call would be admitted as each statement is either an excited utterance, present sense impression, or non-hearsay as shown above. Once again, they did this with the 911 call, saying, Judge, let's go through it. Each statement made by the caller, and we're going to show you why it is admissible. Now, normally, like I said, and they included a transcript of the call itself. I think we've already gone through that one on a previous show, but you get the gist. It's the 911 call. Once again, normally 911 calls aren't really played. They're not really business records. They're hearsay. But if you got somebody that can say, I called 911, do you recall that? What did you tell them? I don't think that's hearsay because they're testifying as to what they said right there. Yes, it is an out-of-court statement being offered truth to matter asserted, but now the witness is there subject to cross-examination. Timing in advance records. Remember, the defense is all spun up about the timing in advance. Timing in advance records refer to data that is used by the providers to estimate the location of the mobile device. The collection of this data is necessary for a cellular network to work properly. Carriers do not retain this data indefinitely. Regarding AT&T, before June 2023, AT&T retained timing advanced records for 7 days. These records were not routinely provided in response to a legal demand prior to June 2023. After that date, AT&T started providing these records pursuant to a legal demand and began retaining timing advanced records for 13 months. In this case, the homicide occurred on November 13th. Bryan Kohberger was identified on December 19th, 2022. Search warrants for his records were executed on December 23rd. At this point, timing advance records were not available for Bryan Kohberger's phone to cover the relevant time period, November 13th. Despite defendants' repeated assertion, the fact of the matter is that AT&T did not provide timing advance records to law enforcement as it relates to Bryan Kohberger's phone. The state is attaching an affidavit from AT&T verifying this, right? There wasn't something nefarious by the prosecution. They can't give you what they don't have. It's not like they intentionally tried to avoid those. I'm sure they would love to have that information. State's reply to the neuropsychological and psychiatric evidence. They say, hey, don't worry about it, state. We'll consider everything as it comes along, but we're still going to get your guys what they're saying. The reply to defendant's objection to the alternative perpetrator evidence. Okay. The state, through their DA, responds to the defendant's objections to the state's motion in limine regarding alternative perpetrator evidence. Although the defendant purports to object to the state's motion and asks the court to deny the same, in truth, the defendant appears to be substantively concur with the legal standard articulated in the State v. Meister case. The defendant acknowledged that he must make satisfactory offer of proof, argue an alternative perpetrator theory. This kind of goes with the Karen Reed case too. Consequently, the court should grant the state's motion and enter an order prohibiting the defendant from offering alternative perpetrator evidence without first satisfying to the court the evidence is relevant and admissible under Rules of Evidence 401, 402, 403. Under Meister, the case that they cite, the defendant's proffer or offer of proof must include evidence specifically connecting persons other than the defendant to the homicide, recognizing that mere inferences that other people could have committed the crime will most likely not be relevant, and if relevant, will still be subject to limitations of 403. Anyway, it says the state further requests the court set a reasonable deadline for the defendant to make any such proffer so that they can deal with it. Reply to state's objection to motion limiting number 6. This is Nolan's touch DNA, contact DNA. This, remember, they were arguing about, what's touch, what's contact, etc. And they're like, if you touch something, that could be touch DNA. It's on something. If they take it from your mouth, that's DNA. Anyway, they go on. The use of term touch DNA will mislead or confuse the jury. In Mr. Kohberger's motion limiting number 6 at pages 3 through 8, or paragraph 3 or 8, he sets forth in detail the history of the use of the terms touch and contact, DNA, and the growing concern with the use of such words. So much that a recent report from the NIST offered the recommendation that analysts should not offer opinions as to how and when that particular DNA sample came on the object. And that's my experience. Most DNA experts won't say how it got there. They're just saying, we swabbed it, we found the presence of DNA, we tested it, and this is what we come up with. So, they go on and on and on. It's kind of a rehash of the same thing, nothing in particular. But what they're saying is the opinion of how the transfer of DNA to Q1.1 is not a proper expert testimony. Now, they're not going to say, well, I opined that Mr. Kohberger must have touched that right before he committed the murders. They're not going to be allowed to say that, but they're going to say at some point, Mr. Kohberger must have come in with contact with that, or someone he touched recently came in contact with that. But anyway, and then they go on and say, Ms. Nolan is not a transfer expert and therefore should not be allowed to proffer as to how the DNA arrived on the sheath as set forth in the motion limine. The expertise for how and when opinions require a different type of expert, and that exceeds the standards of the DNA expert. I would respectfully disagree with the defense on that one. I think the DNA expert can say, I can't say how it got there, but there are many ways. You got touch, you got transfer, you sneeze or something, it can go out there. You just never know exactly how it's going to be there. But that's certainly within their knowledge and expertise as to how it could, in fact, be transferred. Their motion about the 3D model, waste of time, advanced timing records, basically saying, please turn them over. We just heard the prosecution's response, which is, I can't give you what I don't have because they don't exist. Take a look at the affidavit from the carrier, AT&T, expert testimony, and the objections. So that's it, ladies and gentlemen. So in the last couple of weeks, you can see here, what is that? Maybe 3 inches of motions. Stacks up pretty darn quick. It's going to really start getting interesting real quick here in the Kohberger case because these illegal issues are going to be getting resolved. And we're going to get a jury selection. We're going to start sending out juror questionnaires here shortly. And that means game on. So if there's going to be a disposition, like, hey, we'll plead guilty, take the death penalty off the table. If there's something like that going on, we'll have to wait and see. But that's got to be the client's decision to make before they even approach anybody. And then the DAs would have to prove something like that. However, Mr. Kohberger, as we know from his little paper, thinking that he can get away with the perfect murder or how it should be done so the defense cannot attack it at all, I somehow think we're going to trial, ladies and gentlemen. We're going to trial. Next on the docket, Karen Reed jury selection is set to begin. That's right, one day before the start of the jury selection for Karen Reed's second trial, the judge overseeing the case issued a ruling that blocks one of the defense's experts from testifying in the case. That's right, the judge ruled Monday that retired FBI Special Agent Michael Easter cannot be called to testify about his criticisms of the investigation into the death of John O'Keefe. The court finds that the expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. The judge wrote, Ms. Reed is pled not guilty to second-degree murder and other charges, and the prosecution says that she hit her boyfriend, Mr. O'Keefe, with her vehicle outside of a home in Canton during a snowstorm back in January of 2022. Now, following a night of drinking she participated in, her defense team argues that someone else was responsible for killing Mr. O'Keefe, and they're saying that she is simply the victim of a huge police cover-up. Now, hundreds of extra jurors have been summoned for the second trial, and the judge has extended the buffer zone up to 200 feet from the courthouse. Obviously, they're trying to limit people, trying to influence, the jurors, intimidating them, letting them hear what's going on. We need jurors that are going to focus upon the evidence that's presented in trial, not the circus that's going on outside. For those who don't know, Ms. Reed's first trial ended with a hung jury back in July of 2024. And since then, the lead investigator, former trooper Michael Proctor, was fired from the Massachusetts State Police after he admitted to sending inappropriate texts about Ms. Reed during the investigation to other police officers and a friend. Now, Proctor is still listed as a witness for both sides in the second trial. And the Canton police officer, Kevin Albert, and the Massachusetts State Police Sergeant Buchanek are also disciplined in this case. Detective Tully was transferred out of the Norfolk County District Attorney's Office as well. Now, the jury impanelment begins Tuesday, and it will likely take several weeks. Like I said, Ms. Reed is pled not guilty to second-degree murder and other charges. We'll give her that presumption of innocence, and we will see how things go. A couple of other updates. It was a couple of weird. I saw it during my own trial, and I was like, this is weird. So the alternate juror that was on the first case is now on her legal team. Now, my understanding is this woman has no criminal law experience other than being on the jury. That's my understanding, but if somebody says I'm wrong, let me know. I don't see what this person provides other than a headline in the news media for a day or two saying that it was simply a situation where she's so outraged by this injustice she's coming on the team. Doesn't really matter, particularly if you have no criminal experience. What do they need her for? Then the other thing was, guess what? Remember, they're waiting on that appeal. They wanted to continue the jury trial for that appeal to the federal circuit court because they wanted Miss Reed to see if her double jeopardy argument through habeas corpus proceedings would prevail. And I said, that's garbage. It's not going anywhere. I've been saying that argument has been debunked since July or August of last year. And finally, so now the judge, the trial court, the appellate court, the U.S. District Court, state judge, and the appellate courts have all said, no, argument doesn't carry any weight. Everybody knows that. I get it. They're doing their job, but waste of time and money spending it arguing on that for your client. And next, another trial. Lori Vallow. That's right. Lori Vallow, after being sentenced to life in prison in Idaho, is now standing trial in Arizona. Now, Lori Vallow was convicted of murdering her two youngest children, J.J. Vallow and Tylee Ryan, and conspiring to kill her fifth husband's wife, Tammy Daybell. Her husband, Chad Daybell, was also convicted of the same charges, but he got sentenced to death. Well, now she's going to sit in an Arizona courtroom acting as her own attorney on charges of the death of her fourth husband. It's alleged that she conspired to kill Charles Vallow in an attempt to kill her niece's ex-husband, Brandon Boudreaux, as well. The two cases will be tried separately, kind of like what I got. Do one case, finish it up, then go back and do the next one. just like Lori Vallow. She's going to be really tired after this first trial for sure. We'll have to see how that thing works out. Anyway, like I said, this case involves Charles Vallow, her fourth husband. Now, she married her fourth husband back in February of 2006 in Las Vegas, and in 2013, the couple adopted JJ from Charles' sister and her husband, Kay and Larry Woodcock, who were JJ's grandparents. Now, in 2016, the couple moved to Arizona, where they settled down with Tylee and JJ. 3 years later, Charles filed for divorce, indicating he was concerned about Lori's mental health. Now, Lori's older brother, Alex Cox, fatally shot Charles on July 11th of 2019 while he was arguing with Lori after picking JJ up for school. Now, police said during that argument, Alex claimed that Charles hit him over the head with a bat. Alex told police that he was hit in the head. He retrieved a gun from the bedroom and shot Charles in self-defense. In the probable cause affidavit from the Chandler Police Department, investigators said no emergency aid was provided to Charles, and he was left bleeding on the floor for approximately 34 minutes before the 911 call was made. A grand jury indicted Lori for the charge of conspiracy to commit murder as it relates to the death of Charles Vallow. We'll see how that one goes, ladies and gentlemen. That one's going to be a hoot. Hopefully, I'm done with everything, so by the time evidence is being presented, I can sit here and enjoy it with you. But I think it's going to be a hoot. Now, wouldn't it be ironic if she won? You never know. That would be the worst nightmare for any prosecutor, losing to a pro se defendant. All right, next, I think we can all agree on this. Keeping dead bodies in a storage unit is creepy. It's weird. Well, a former funeral home owner in Mississippi has been accused of using a storage unit to illegally store bodies, even going so far as to describe it as his casket warehouse when he puts up TikToks. Apparently, he lost his business license, so what do you do when you got those leftover bodies? I guess you just take them to the storage shed. Anyway, the police down there in Mississippi and Washington County specifically, and the police chief, Deputy Billy Barber, made a statement that he believed that Mr. Creeth was trying to continue hosting funerals and burials, which he advertised for on social media. He said the bodies were discovered during a suspected burglary. Anyway, videos posted on Mr. Creeth's website show that he goes by Funeral Home CEO online, and it shows him stowing away caskets and other funeral items inside of the storage unit. Now, police say that they are probing the former funeral home owner and his actions since losing his business license to see if any charges are warranted. Most states have rules on how you're supposed to treat the bodies, and like if there's time, and we've had a couple of those. I don't know what it is, but funeral people are always getting in trouble. You know, throw them in the oven, throw them over here, don't bury them, say you buried them. It just becomes a big, big mess, ladies and gentlemen. Probably want to check them out before you make sure they're reputable. Make sure they're reputable. Next, this day in legal history, 1871, Williams Wooden Holden, the North Carolina governor at the time, becomes the first U.S. governor impeached and convicted, removed for abuse as tied to civil rights enforcement. On this date, March 31st, 1882, Jesse James, infamous outlaw, is shot dead by gang member Bob Ford in Missouri, ending a 16-year crime spree for robberies and murders. On March 31st, 1918, Congress establishes daylight savings time, the measure to conserve resources during World War I, impacting national timekeeping laws. Hate it, hate it, hate it. On this date in 1951, the 22nd Amendment limiting presidential terms to 2 is ratified, becoming a cornerstone for the U.S. constitutional law. On this date in 2005, the United States Supreme Court in Roper v. Simmons bans the death penalty for crimes committed under the age of 18, by people committed under the age of 18. Has to do with juvenile justice and the 8th Amendment, cruel and unusual punishment. And then finally, our dumb criminal of the day. Yes, the police officer said, "You look like a clown," to Christopher Marlowe after stuffing him into a police car. Mr. Marlowe responded back, "No Shit, I'm a clown, stupid. Marlowe, who was wearing a Ronald McDonald costume and a red nose at the time. Now, police confronted Marlowe Monday afternoon at a Palm Bay, Florida shopping center for which he had previously been trespassing. Don't go anywhere, Chris, a cop announced. You're not free to leave. As seen on the body-worn footage, Marlowe struggled with officers before he was knocked to the ground and handcuffed, and one cop can be seen removing an orange replica gun from a pocket of Marlowe's yellow pants. Now, completing the whole look he was going on there, Marlowe wore a red and white striped shirt and a yellow vest, which had a skull logo in place of the McDonald's arches. He was not wearing the oversized red shoes, however. Anyway, Mr. Marlowe's backpack turned up on multiple other clown outfits and a pack of 10 red noses. Now, charged with trespassing, a misdemeanor, and resisting officers with violence, a felony, Mr. Marlowe was booked into the Brevard County Jail. He's locked up in lieu of $5,500 bond and is scheduled for an arraignment on April 17th. Mr. Marlowe has an extensive rap sheet, including trespass, resisting arrest, possession of drug paraphernalia, and in January, he pled no contest to possession of methamphetamine and a glass pipe. He got 65 days in jail for that offense, and Mr. Marlowe has been arrested in that case after causing a disturbance outside of a McDonald's restaurant. Go figure, ladies and gentlemen. Hey, you got to appreciate the guy's hustle, right? I'll dress up as a clown. Maybe someone will take their kid's picture with Ronald McDonald. Somebody pays him a few bucks. He can get a little more meth. You got to admire the hustle, right? You got to admire that about drug users. They get up every day and say, I got to hustle my butt to get my quota, to get my drugs. A lot of lazy people out there, ladies and gentlemen, but drug users, they know what they got to do. Anyway, Mr. Marlowe, you are a dumb criminal of the day. And for those who are offended by that, it was a joke. It was in jest, all right? So you don't have to send that to me. Don't do drugs, ladies and gentlemen. Don't do drugs. It gets you in trouble. All right, thanks for watching. We'll see you next time. Have a wonderful day. And remember, the Constitution matters.